We had more attorneys earlier.
Juan, could you go find me some attorneys? Tell them I'll give them more time to talk after the break, but I'd like some attorneys. No, tell them to come down now. They can talk to him during lunch.
1519, 1510. Just a price and 1054 on that 251.
Okay, we're back on the record in State of Florida versus Reeves. The defendant is present and is dressed out. The defense is present. The state is present. Ms. Sumner has not yet returned to court. Ruling on the request to close court and prohibit the viewing of the video by the media and or by the public. I'm not going to close court. The video is still part of discovery, and it's subject to the 30-day hold on dissemination. However, I don't find that the Lewis standard has been met to close court. The legitimacy of our court system and the strength of our democracy is fostered when the public has broad access to court proceedings. Withholding this video from public view would only fuel speculation about what is on it. If the video is played in court, then the media can tape what any member of the public could see off of the screen if that member of the public was present. Now, that being said, State, are there any other motions I have to hear before we actually begin this bond hearing?
No, Judge.
Defense, anything else I have to hear before we start this bond hearing?
There we go.
All right. The State's filed an information in case number 14216, CFAES, for murder in the second degree. Within that information, the State has alleged the use of a firearm causing death or great bodily harm. A second-degree murder carries a guideline score within the Criminal Punishment Code of Florida Statute 921 of... No problem. Of approximately 21 years at the bottom of the guidelines under Florida law, up to 30 years or life. Where a firearm is alleged under Chapter 775.087 of Florida statutes, there is a minimum mandatory 25-year sentence that the court must impose if the defendant is convicted as charged with findings made by the jury. Within the information filed in this case, the state has included the allegation of firearm and invoked the 25-year minimum mandatory sentence. There is no discretion for a purpose in Mr. Reeves' position which is given to the court as it relates to that 25-year minimum mandatory sentence. That means, Mr. Reeves, if you were convicted of the charge as filed, that you would not be eligible for release until a minimum of January 13th of 2039. You also have to understand, and this is basically the arraignment is what I'm doing here, you
You also have to understand, even if I did not agree with that sentence, whether I agreed with it or not, I would have to impose it because it's a mandatory. There's no discretion. I review these details and these laws with any person that's charged with a homicide, and so I've reviewed them now with you as a part of your arraignment. To that end, traditionally a formal arraignment date would be set, but since we're all here and since it's difficult to transport, I'm going to go ahead and arraign you today. You already have counsel, so we've settled that issue. We're going to do the bond hearing. Mr. Escobar, at this time, what plea does your client enter?
Not guilty, Your Honor.
Okay. Now you've been arraigned, and now we proceed to the bond hearing. Yesterday I discussed the option and possibility of setting a trial today, specifically now before I hear the bond hearing and anybody knows if somebody's getting out or somebody's not getting out. That being said, I had a short conversation with the attorneys after court just about scheduling and coordinating potential scheduling. And at this time, State, would you be asking me to set a trial date, or would you not be asking me to set a trial date?
No, sir, Judge.
Not asking. Defense, would you be asking for me to set a trial date, or would you want a pre-trial 30 to 60 days out?
Pre-trial.
Pre-trial. Okay. So that being said, I was going to offer the opportunity to do opening statements.
One other thing that I
Sure.
want to advise the court judges, there was a second count, the aggravated battery count.
Oh, you're right. I did not advise on that.
Yes, sir.
Mr. Reeves, you've also been charged in count 2 under chapter 784.045 sub 1A sub 2, an allegation of aggravated battery, and they have also indicated firearm within that allegation, and that allegation includes discharge of a firearm. By including discharge of a firearm under chapter 775.087, that carries a minimum mandatory 20-year prison sentence. If you are convicted, again, that is a minimum mandatory. The court would have no discretion. All right? Thank you, Mr. Garcia, for reminding me of that.
Yes, sir.
So, to that end, defense, do you wish to give an opening statement before you begin your bond hearing, or go directly into witnesses?
Your Honor, we've supplied the court with an extensive memorandum. We're going to waive at this moment the opening statement.
All right, I have a copy of your memorandum. I have reviewed it in its entirety. I believe it is 24 pages with attachments A through E, and then also attachments 1 through 18. And I reviewed the letters as well as the case law that you cited.
Thank you, Your Honor.
State, do you wish to give an opening statement, or do you wish to go directly into witnesses?
Judge, I'd like to give an opening statement, please.
You may proceed.
May it please the court, Mr. Escobar, Mr. Michaels. Judge, good morning. Your Honor, I expect the evidence is going to show that back on January 13th of 2014 at the Cobb Movie Theater located here in Pasco County, Florida, that you're going to hear testimony from Charles Cummings, an eyewitness in this case. He's going to tell you that he and his son had gone to the movie theater to see The Lone Survivor. He was going to tell you that he was in a theater with Mr. Reeves, Mr. Reeves' wife, Mr. Olson, Mrs. Olson, and obviously other people who were eyewitnesses to the events that happened on that date. He's going to tell you that he was sitting in the same row as the victim. He was about 2 to 3, maybe 4 seats away from the victim when this transpired. He's going to tell you that there was words exchanged by Mr. Reeves in this case, along with Mr. Olson. He could not hear what was being said. However, he's going to tell the court that in his opinion, Mr. Reeves was agitated, he was angry, he was grumbling. He's going to tell you that at some point in time, Mr. Reeves gets up and he walks out of the theater. As he's doing so, he's hitting the seats behind him and he's grumbling. And Mr. Cummings is going to tell you not only does he hit the seats, but he kicks the back of his chair, obviously agitated. He's going to tell you that shortly, he's not sure about the time period. It could have been 2 or 3 minutes. Mr. Reeves comes back to the movie theater. He sees that he kind of leans forward. Something is said to Mr. Olson. Mr. Olson then stands up and says something to the effect that he was texting. He wasn't sure what was said. He says he sees popcorn flying. He then sees the gun go off. He hears the defendant state something to the effect, "Do that to my face." Shortly thereafter, he's going to tell you that he sees Mr. Olson walking in the same aisle that he was in. He's stumbling, and he makes a statement, "I can't believe he shot me." He's going to tell you that there was no obstructions. The visibility was good. It was dimly lit, however, he could see. He could see Mr. Reeves. He could see Mr. Olson. He's going to tell you that he did not observe anything in Mr. Olson's hands. He did not see any punches exchanged, no strikes, no hits, nothing that would indicate to him that this gentleman, Mr. Reeves, was threatened in any way. He's going to tell you if he had seen any of these things that he would have intervened. You're going to hear also from Mark Turner. Mark Turner is a retired lieutenant colonel with the United States Air Force. He's going to tell you that he was in a clandestine case officer. He's going to tell you as part of his duties with the United States Air Force that his job was to observe things. He was in intelligence. He's going to tell you that he's done that his whole entire career, and he's done that in his private life. He's going to tell you on January 13th of 2014, he was in the movie theater with his wife. They were there to see The Lone Survivor. He's going to tell you that he hears conversations, he hears things transpiring between Mr. Reeves and Mr. Olson. He is going to tell you that Mr. Olson never got out of his chair. He was never invading Mr. Reeves' space. There were no threats. He never saw Mr. Olson strike, hit, or threaten Mr. Reeves in any way. He's going to tell you, Your Honor, that he hears the pop, he sees the muzzle flash. And Mr. Turner is going to tell you that he hears a statement attributed to Mr. Reeves, and he said, "Throw your popcorn in my face, will you?" And he hears Mr. Olson state, "I can't believe this," as he's walking down the aisle after having been shot in the chest. Your Honor, you're going to also hear from Deputy Alan Hamilton. He was at the movie theater with his wife. He's going to tell you that he was there. He heard a confrontation or voices between Mr. Reeves and Mr. Olson. He's going to tell you that as a law enforcement officer, he did not think that it rose to the level that he had to intervene. He thought it was just them having words that someone was going to get up and move. He's going to tell you that he hears Mr. Olson saying something to the effect about texting his daughter, so on and so forth. He's also going to say that he sees the muzzle flash. He walks over to the defendant in this case, Mr. Reeves. And as he's sitting there, he's going to tell you that Mr. Reeves continued to try and get up out of his seat. He's also going to tell you that he wanted to touch the cell phone or pick up the cell phone that was at his feet. Deputy Hamilton is going to tell you that he stood there. He took the gun away from him. It was a .380 semi-automatic pistol. He took the magazine out. He took the round out of the chamber. He held it there, put his hand on Mr. Reeves and said, "You just need to stay here. You just need to stay put. Don't do anything. They're going to be coming in here. I don't want to get shot. I don't want you to get shot." He's also going to state that Mr. Reeves said, "I can't believe I just done that shit. What happened?" Mr. Hamilton is going to tell you that at no time did he ever see Mr. Olson strike, hit, or threaten Mr. Reeves in any manner or any fashion. He's going to tell you that he did not observe any injuries on Mr. Reeves, even though Mr. Reeves had, at one point in time, put his head back, tilted his glasses up, and told him, I got hit in my left eye, I was hit. Mr. Hamilton's going to say that he was there. It seemed to him to be, Judge, an eternity. As he was looking at Mr. Reeves' face, did not see any injuries on his face, or his hands, or anywhere else. You're going to hear from Derek Friedhoff, Your Honor. He's a registered nurse. He was at the movie theater with his girlfriend. He advised that he saw what was going on. There was a confrontation. He heard it. He was looking over his right shoulder. He could see what was going on. He could see clearly what was happening in this case. He sees the victim in this case, Mr. Olson, standing. He never sees him with anything in his hands. Never sees him in any way, shape, or form touch, strike, or hit, or threaten Mr. Reeves in any manner. He sees a muzzle flash go off. And he hears after the muzzle flash, the defendant state, "Throw popcorn in my face." He is going to tell you that Mr. Reeves had been shot, the center mass in the center chest. Being a nurse, he started doing compressions, and he awaited for the arrival of the paramedics, so on and so forth. Judge, you're also going to hear from Detective Alan Proctor, who's a case detective. He's going to tell you that he spent quite a considerable time with the defendant in this case, Mr. Reeves. Mr. Reeves kept telling him that he had been punched on the left side of his head. Detective Proctor is going to tell you that on that date and directly after that incident, he did not observe any injuries on Mr. Reeves at all. He's going to tell you that he had the defendant photographed and that the pictures actually depict the lack of injuries to Mr. Reeves. He's going to tell you that his hands were also photographed. Detective Proctor is going to tell you that there's an abrasion on his left hand. He's going to tell you that in his training and experience and for being a law enforcement officer for approximately 30 years, it's consistent with the handcuffs rubbing his skin and causing an abrasion. Judge, it's our intention that we are going to play the taped interview of the defendant in this case after he was read his Miranda rights by Detective Alan Proctor. And Judge, we're going to ask this court to compare his version of events to the events of the independent witnesses in this case, along with the videotape. And you're going to see that his version of events do not corroborate, nor are they corroborated by the independent witnesses, nor the videotape. In addition, Judge, as you know, the state of Florida has a burden of proof in this case. We have to prove in this bond hearing proof evident. Presumption is great. And I would submit to you, at the conclusion of this hearing, the state of Florida is going to have met that burden, Judge. And we're going to ask that you continue to detain Mr. Reeves in the custody of the Pasco County Sheriff's Office under a no bond status. Thank you.
Thank you, Mr. Garcia. Mr. Escobar, who do you wish to call as your first witness in this bond hearing?
Your Honor, we're going to be calling Thomas DePaulis. I would ask the court if we're going to break. He's probably going to be a lengthy witness. I hate to break his testimony up if at all possible.
How lengthy are we talking about?
I would imagine at least 45 minutes.
Let's see how much we can get done.
Okay.
What's his name again?
Thomas DePaulis.
Thomas DePaulis. Put it down for Thomas DePaulis, something. How do I spell his last name correctly, please?
DePolis.
Good afternoon, sir. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? So help me God. Come on up and take a witness stand, please.
May I proceed, Your Honor?
You may inquire.
Please state your full name for the record.
My name is Thomas Anthony DePaulis.
Mr. DePaulis, what is your educational background?
I have a master's degree in criminal justice. I earned it while I was working with the Tampa Police Department, and I hold several certificates from nationally recognized institutions such as the FBI National Academy.
Let's talk a little bit about your employment. Tell the court, for the majority of your life, what your employment history was.
My employment was law enforcement for the majority of my life. I spent 26 years with the City of Tampa Police Department, and after retirement there, I went on to the Hillsborough County Sheriff's Office, where I was appointed as the Chief Deputy for another 6 years.
Okay. Let's take the court, if we can, just briefly through the history of your work there at the Tampa Police Department. Started in patrol?
I started in patrol, yes, sir.
What year did you start in patrol?
It was 1967.
And tell the court how you moved up through the ranks of that department.
Well, in that department, you must take promotional exams in order to be eligible to be promoted. I did those. I attended some college while I was working on my days off. That always helped toward promotion. The first promotion is the rank of corporal at Tampa, and it's 1 year I was promoted to the rank of corporal and then proceeded from there. Went to sergeant, and all the way up until the end of my career, I was the deputy chief of investigative services. And at the time, that was the second in command rank at the Tampa Police Department.
So the chief was had higher rank, and you were next.
Yes, sir.
Okay. And how long did you hold that position, deputy chief with the Tampa Police Department?
Approximately 3 years.
Okay. Do you know Curtis Reeves?
Yes, I do.
And would you tell the court how it is that you came to know Curtis Reeves?
Well, we were both the rank of sergeant at the time, so we had experience beyond the basic level, and we were what was considered first-line supervisors. The Tampa Police Department did not have a specialty team to respond to highly dangerous situations, and the chief of police at that time came to us and asked us to form a SWAT team, as it was known. He didn't like the term SWAT, so we named it something else, but we began forming the basis for selecting and training and equipping members of a SWAT team.
Let me ask you this. Did you know Mr. Reeves prior to your contact with the SWAT team or starting that program as a sergeant?
I knew him as a sergeant in the police department. I had worked off and on with him. We didn't work closely together until we started forming that team.
Okay. So what year was it that the chief asked you and Mr. Reeves to form this highly specialized group?
It was in the mid-'70s, so I know we started attending training for different aspects of training for that particular group in about 1977. So, it was somewhat just before that, before we would have started attending training.
Describe to the court how intensive that training was in order to be able to formulate such a group that would respond to highly dangerous situations.
So at that time, you have to remember, there was no specialty team that made any kind of response to a dangerous situation. And the term SWAT actually is the 4 letters stand for Special Weapons and Tactics. So together we decided we better learn some special tactics more than the weapons. The weapons we could accumulate and see what was out there. The tactics, which translates to strategy, was much more important. And that's the part we didn't know. The advantage a SWAT team has over basic police law enforcement would be that they plan for things, they're prepared for things, they've gone over different scenarios so that they would come up with strategies on how you would react to different levels of danger. So we began with the FBI.
Let me stop you there for a second. Are you telling the court today that in implementing this special squad, that yourself and Mr. Reeves went to schools throughout the country in order to educate yourself on those particular techniques that you needed to employ in order to recognize danger and act appropriately?
Yes, sir, that's exactly what I'm telling you.
And the reason that you had to go and get that specialized training was because you were going to be training, likewise, the new members of that squad?
That's correct. We were going to be selecting. We needed to know what to look for, and then we'd be training, and then we would actually be putting into practice those same tactics with those same individuals.
So you designed, you and Mr. Reeves designed this tactical squad, trained yourselves by going to schooling across the country.
Yes, sir.
And then did the training, the selection and the training of those men that became the first tactical squad for the Tampa Police Department.
That's correct.
Just give the court just a rough figure of the number of hours that Mr. Reeves and yourself had to spend going throughout the country to educate yourself on these proper techniques.
Well, I imagine it would have to be hundreds of hours. I don't have a number in my head, but for example, the very first FBI SWAT training that we had was at Quantico, Virginia, at the FBI Academy. It was a week long, and that was followed up with dozens of hours afterwards. We went to the United States Army Counter Sniper School in Fort Benning, Georgia. And that was, again, another week or 2 long, again, followed up by countless hours of follow-up training for that.
the Secret Service Dignitary Protection in Washington, D.C. You know, those are the kinds of places we went to get the information we would need and the training we would need to bring back, make the proper selection, make the proper policies, select the right people, and then begin that training.
Mr. DePaulis, that training is far more intensive than the training that you get as a new officer going to the academy. Is that correct?
Yes, sir. That's the point of the training, so that the officer on the street has enough to enforce the law and has policies to regulate his actions in enforcing those laws, but perhaps is not prepared for every kind of situation that he might encounter that's more than he can handle. That's the purpose of a specialized team, is to have weapons that will help them accomplish what the officer may not, and to have already thought out some strategies for taking action where the officer may not have time to think of those.
Okay. And so now one of the first courses that you go to is to the FBI school in Quantico. Is that correct?
That's correct. That's one of the early schools.
And this was a school specifically designed to teach you those particular tactics in order to deal with dangerous situations.
That's correct.
Do you remember ever them instructing you during that period of time concerning factors that individuals had to assess in determining danger, the escalation of danger, and how to properly respond to danger?
There were a number of factors, and we would study at the FBI Academy, for example, different scenarios that law enforcement officers had been in around the country where things had failed for them, things had gone wrong, and officers had died or innocent people had died. You were to learn from mistakes in a basic sense. And then we would come back and we would discuss some of those issues with our team, train on those issues, and play what-if scenarios. What if we encountered someone who was barricaded? What if we encountered someone who was trying to kill himself, but if we let him go, he would be a danger to the public? At what point would it escalate to the point where we needed to take action on our own, or could we fall back and try to negotiate with the person? That was the kinds of strategies that the officer on the street, the uniform officer, didn't have time to think of. And that's what we would prepare ourselves so that we could go there and have those strategies in mind.
You've defined this as strategies, and I've asked you about factors. Lighting conditions, is that a factor for officers to consider when they're dealing with an issue that could be dangerous, that they're perceiving whether the danger is imminent or whether the danger is controllable?
Yes, sir. All of the environmental factors would be in consideration. Lighting would be certainly one of them. Noise would be another one. When we arrived on tactical situations, sometimes we tried to control the lighting or the noise, those kinds of things. So, yes, sir, every environmental factor I could think of would be a part of that decision.
Why is lighting in particular an important one?
Well, it depends on your point of view. If you're in a bad lighting situation and you're faced openly with danger, you can't see the danger clearly. If you're trying to...
I'm going to object to the relevancy of this testimony. I don't see how lighting and these type of questions by Mr. Escobar is relevant to a bond hearing.
Oh, right.
Lighting, the lighting question, yes, sir. If you were confronted with some dangerous situation, lighting would be important to you because you'd want to see what the danger was and how much of a threat it was. In our situation as a tactical team with a prepared plan, we may want low lighting so that we could move in closer to someone who was armed and apprehend them without problem. So the lighting is a factor in either side of that equation.
Okay. What about your physical abilities or physical disabilities?
That's very important. We would have continuous fitness evaluations. We would, much of our training we got to train once a month with our agency. They were generous in that way. And much of the time spent in that training day was spent on physical fitness, running, strength building, those kinds of things, making sure that we were strong enough and agile enough to accomplish whatever it needed to be accomplished.
What about physical disabilities?
Physical disabilities would obviously be a hindrance, and you would know that you couldn't do things. If we had someone who was injured and on light duty, they couldn't participate in the training, nor could they go on a call-out, so to speak. We could not afford to be hindered in the work. You had to have people who were able to perform the duty. and not become a part of the burden. Once you're inside of a situation that you can't get out of, everybody has to be able to function.
Mr. DePaulis, did you ever study and teach, you and Mr. Reeves, teach your group factors concerning a dangerous individual and how to assess whether an individual was dangerous or not?
Yes, sir. We would have discussed that probably at length with our group, and some of the things, since you're talking about an individual, some of the things you would watch for in an individual is that they're acting differently than a normal person, obviously, and that they're either escalating in anger or frustration or anxiousness, something that would cause you to be concerned about the changing condition.
Why would that be concerning to someone that you were confronting, that they were acting highly abnormal for the circumstances?
Well, because that could be an indicator of them being dangerous and acting outside of a normal way. If they were relaxing and calming down, in other words, perhaps exhausted their anger, and then you wouldn't need to act as quickly. But if there were other dangers involved and the person was becoming more and more agitated, you'd have to watch that closely to some point and make a decision on whether you needed to take action or if you could continue to try to negotiate.
Facial expressions. Is that a factor that you consider when an individual is...
Yes, sir. I mean, all body language would be, and facial expressions would be a part of that. The entire body language, you can pretty much, after training and watching other law enforcement officers in situations and in your own experience, you can pretty much tell by the body language of an individual whether they're getting ready to act aggressive or whether they're backing down from a situation. We always hoped that we could outlast them and let them back down, but if it escalated, then you'd have to make a decision on what action you should properly take.
How much time do you have to assess all these factors and make a decision?
Well, if the individual was barricaded and there was no one else in danger, we could take hours, we could take days, and we had taken that long, as a matter of fact. It depends on if someone else is in danger, if someone is a danger to themselves. On some calls we were called to prevent suicide, and so that person's a danger to themselves. So if it happens that it's going to involve someone else being harmed, then you had to make a pretty quick decision.
Individuals' proximity to you.
Yeah.
Is that a factor that you consider?
Oh, absolutely. We would consider how fast someone could close the distance between us, and how quickly we would, if they were armed, how quickly we would have to react to that. If they weren't armed, how quickly could they get to us and cause us not to be able to do what we needed to do? Yes, so we assessed all those things.
So proximity was a major factor?
Proximity was one of the major factors, yes, sir.
Were you concerned at any point in time during these encounters with someone that was dangerous that they would strike you without a weapon?
You had to be concerned for that, yes, sir.
Why?
Well, you could be incapacitated by a strike and put yourself in danger, or your teammates in danger. So, the more you knew about a weapon, obviously the more you would consider that. But the absence of a weapon didn't make it safe.
So when you were instructing your men in this tactical squad, were you instructing your men to say, hey, listen, if the person doesn't have a weapon, you can't use deadly force?
No, we would never say that to them. They have to make their own judgment about whether or not they felt threatened enough to rise to the occasion to use deadly force.
A fist can cause some pretty severe damage?
It can.
You've had how many years with your force?
I had 32 total, 26 with Tampa.
A fist can cause severe damage?
It can.
Death?
It can. It can result in death.
This is not something I'm telling you. You learned this at the FBI Academy, correct?
Learned it and experienced it through my working as a police officer.
What about the age of an individual? Take that ever into consideration?
Well, the age, the physical condition, size, yes, sir. All of the environmental factors related to the individual as well as to your environment.
You know, here in Florida, we have a law that says that if you batter someone 65 years of age or older.
Judge, I'm going to object.
Sustained on that one, Mr. Escobar.
Oh, I'll move on here.
I don't realize he doesn't need to instruct me on that.
Let's talk about how this team evolved. I think we've gotten into all of the factors that you learned throughout the process. You hire your recruits. Tell me what type of situations you're called upon.
Well, first off, the team members would be selected from experienced officers, so we would have.
Judge, I'm going to object. Can we approach, please?
I guess yes, I wasn't sure.
Well,
You're coming up, so it's
okay. No, it's okay. Come on.
For clarification, the state's objection was to the relevancy of the testimony. I understand the objection, and if this were a jury, I would be concerned that things were going before the jury that might not necessarily be entirely relevant and might be prejudicial. However, I'm not a jury, and this isn't a jury trial. This is a bond hearing. I know it seems like a jury trial in a lot of respects, but it's just that. It's a bond hearing. To that end, State, your objection to relevance is continuing, and I understand it, and at some point, a question may be asked that may cross the line, and I might at some point stop you, Mr. Escobar, at this point, so he doesn't have to keep standing up and jumping up and objecting. I don't want him to have to do that, and I don't want him to interrupt your flow. That being said also, Mr. Garcia, you're asking me to hold a man who's 71 years of age, who's never committed a crime in his life, best I can tell, until the allegation that brings us here today, without bond prior to him being convicted of anything. So with that in mind, I'm going to let Mr. Escobar ask as many questions as he feels he needs in order to make his client's case, because this is a request for a pretrial detention on a non-capital felony, and the court would take very seriously the idea that I would detain somebody without them having been convicted of anything prior to trial. So I want him to ask as many questions as he feels is appropriate. If you go out of bounds, I'll stop you from this point forward, okay? All right.
Mr. DePaulis, take us through the inception of this group and how you all progressed in the tactical response team with the Tampa Police Department. I understand at one point you all became elite status. Is that correct?
We did, sir. From the very beginnings, there weren't a whole lot of SWAT teams around except in some of the larger cities, LA being probably the most noticeable. And we took lead from a lot of the things they did, but a lot of it came from the federal agencies as well. We started with minimal equipment, and as we got better at what we did, we improved on that equipment to what was more modern, better protection for the officers who were involved. Our tactics, I keep calling them strategies because in my mind that's what they are. Our tactics improved, our strategies for handling situations improved with our experience. I mean, in the beginning we didn't even have a hostage negotiator. Curtis Reeves and I did all the negotiating, and we realized that that wasn't really our specialty. We needed to come up with a team of hostage negotiators as well. So that's the kind of progress we made. We gained a favorable reputation in the state, and actually they began state competitions of SWAT tactics. And we went to some of those, won them, and that led to national recognition. So the team is still in existence today. It's improved as the as the environment has needed it to improve, and it's been involved in, I couldn't tell you, countless situations, some of which have resulted in death and some of which have resulted in the discharge of firearms, and the overwhelming majority have resulted in the apprehension of someone who needed to be apprehended without any violence occurring.
Let's talk about the commander of that group for 16, 17 years. Who was that?
Well, in the beginning, there was only he and I, and so the chief of police put an administrative commander in between us. And I happened to get promoted. I was more fortunate. I happened to get promoted before Mr. Reeves, and so I was put in charge. I got promoted out of the team. I was too much involved in management to be able to go to those call-outs, and Curtis Reeves was in charge of that team.
And was he in charge of that team for 16, 17 years of his service as a law enforcement officer to the Tampa community?
He was.
Okay. The time that you were able to see him out performing training, educating his men and educating the other SWAT teams around the country, tell the court what your experience was and how Mr. Reeves carried out that duty.
He was always extremely professional about what he did. He would be the one who would come up with suggestions such as, these World War II weapons that we're using are not very accurate, and we're going to get somebody hurt that doesn't need to be hurt. We need to convince the chief that we have more modern weapons, and then we need to go learn how to shoot those weapons. Those were the kind of ideas he would see shortcomings and potential shortcomings that might affect our how well we did our job in protecting the public, and he would make suggestions for training or improvements to do that. He always performed at an excellent level and expected excellence from those around him.
At any point in time during your service with Mr. Reeves, did you ever see him lose his temper?
Well, I imagine it would be a lie if I said I never saw him lose his temper. He probably lost his temper. I can't remember a specific incident because I don't remember him ever overreacting and losing his temper. He may get mad at something. It may be a policy. It may be something stupid that an officer did, and he didn't like stupidity. He liked people to think and be professional. So I can't say that I didn't see him lose his temper. I can't remember an incident specific in my head that stands out where he did.
Okay. Mr. DePaulis, did you get to know Mr. Reeves personally as well as professionally?
Yes, sir. In that kind of a team, you get pretty close to one another. You get to know each other's families. So I knew him as a man. Yes, sir.
Tell the court what your experience was in your professional relationship with Mr. Reeves.
Well, personal relationship. He was as dedicated as a family man as he was as a law enforcement officer. They both were equally important to him. He was what people would describe as a good man. I don't know of anything in his background or his history, in his personal life, not just on duty but off duty, that would cause any kind of someone to say something bad about him. In fact, he was so professional that while I was at the sheriff's office as the chief deputy, some of the senior members of management at Busch Gardens came to us and asked us for a recommendation for the security director. And I talked to some of those people at that time. They said they weren't interested in a suit, they called them. They didn't want a retired FBI agent or Secret Service. They wanted somebody who had been a good street cop, a municipal cop. And Curtis Reeves' name was the first one that came to my mind. I recommended him, and they hired him straight up.
Do you know how long Mr. Reeves worked as the director of security for Busch Entertainment?
I don't. I was at the sheriff's office for 6 years, and I'm almost positive he was there longer than I was at the sheriff's office, but I don't remember when he left.
As you sit here today, you've known Mr. Reeves for how many years?
Well, how long is the mid-'70s or earlier?
Do you have any concerns as you sit here, in your professional opinion as a former decorated officer yourself, do you have any concerns that Mr. Reeves is a danger to any Florida community if he were released on any form of pretrial release?
I have nothing in my affiliation with him that would lead me to believe he's a danger to the community. Nothing.
Is there anything that you would feel that Mr. Reeves somehow would be a risk of flight if this court were to set reasonable conditions of pretrial release?
I can't imagine that, sir. He's like me. We wait on our next retirement check, so I don't think he's going to go any farther than that.
No further questions, Your Honor.
Thank you, Mr. Escobar. Who would like to question for the state?
I would, Your Honor. May I have a moment, please, Judge?
You may. At the conclusion of this questioning, we'll take our next break. Because we're not going to finish anytime soon, we're going to make it the lunch break. It will be for 1 hour. And when I say 1 hour, it'll be precisely 1 hour. So everybody can govern themselves accordingly. Mr. Garcia, you may inquire.
Thank you, Your Honor. May it please the court. Mr. Escobar, Mr. Michaels. Mr. DePaulis, good afternoon, sir.
Good afternoon, sir.
Mr. DePaulis, you would agree with me that Mr. Reeves has had extensive training in assessing dangerous situations?
Yes, sir.
And in fact, he has the ability to recognize and act appropriately, as you indicated, in these situations, correct?
I think his training and experience would make him uniquely prepared for that, yes, sir.
Okay, and you would agree with me in that training, you are also trained how to de-escalate situations, correct?
If possible, yes, sir. You are trained to do that if it's possible.
You indicated that there's factors that you look at in assessing a person or a situation, correct?
Yeah, that's correct.
All
I
right.
did say that.
If a person was grumbling and kicking seats, are those acts of aggression in your mind?
They may be acts of aggression. There may not be acts of aggression that would lead you to think that someone's going to be harmed, but certainly they could be acts of aggression, yes, sir.
And I think you indicated, and correct me if I'm wrong, but you had said that you are trained in assessing situations when there's an absence of a weapon.
That's correct, yes, sir.
In your line as a law enforcement officer for how many years?
32.
32 years. Did
Yes,
you
sir.
ever shoot an unarmed person?
No, sir.
Does the absence of a weapon allow you or authorize you to use deadly force?
It could, yes, sir.
You indicated that you never saw Mr. Reeves lose his temper, correct?
No, I didn't say that, sir.
He said he couldn't specifically remember an occasion.
I said I'm sure I must have seen him lose his temper. I cannot remember an occasion that stands out in my mind. It never rose to that.
So if I understand you correctly, you're not telling this court that Mr. Reeves has never lost his temper.
That is correct.
If I understand you correctly.
That is correct. I'm
Okay.
not saying that.
Now, you indicated that you felt that he was not a risk to the community if he was allowed out on bail?
Nothing in his professional career, nor the time that I knew him personally, would lead me to believe that he would be a danger to the community.
And you would agree with me that you would not think he was a danger to the community back on January 13th of 2014 either?
That would be correct, sir.
Just to clarify, did you ever see Mr. Reeves lose his temper?
As I stated, sir, I must have. I just can't recall. It's never stuck in my mind. I don't know. I've known him 40 years. He must have, but I just don't remember an incident where he did.
When's the last time you spoke to Mr. Reeves?
Last year, a mutual colleague had passed away, and we were at a funeral, and I spoke to him at that church funeral.
Okay, and when was that? You said last year.
I don't remember if it was the beginning of the year or the middle of the year. It wasn't cold, but that doesn't tell us much in Florida. I don't remember exactly when the funeral occurred,
Okay.
but it was in 2013.
Okay, I was going to say, is it fair to say that it was sometime in 2013?
Yes, sir, it was in 2013.
Prior to that, had you had any conversations with Mr. Reeves?
I have not since I had left the sheriff's office, which would have been 1999. I don't remember talking with him since then.
Okay, so since 1999 till 2013, where you saw him at the funeral.
Right.
You had not had any conversations with him?
I don't remember having any, to be honest with you.
Did you have any social gatherings with him? Did you have dinner with him? Did you?
During that period of time, I don't remember if I did or not, sir. I just don't. I did. Nothing stands out in my mind as having done so.
You indicated that the SWAT team back then had attained the status of an elite status, correct?
Nationally recognized, yes, sir.
Okay. And Mr. Reeves was part of that tactical team that had obtained this elite status?
Yes, sir, that is correct.
Being a SWAT team member or a tactical member, did you practice drawing your weapon from your holster?
Yes, sir.
And how many times would you do that?
Probably thousands, I'm not sure, sir. And I don't have a number in my mind, but it would have been done frequently.
Did you observe Mr. Reeves do that same thing? Did he practice taking his firearm from his pocket or his off-duty weapon, drawing and firing?
Well, are you saying from his off-duty weapon or his holster from...
Either one.
I would have observed him drawing from a holster. It would have been a duty holster either from uniform or the SWAT team holster.
Okay. And you would agree with me, as a law enforcement officer, you all are authorized to carry firearms off-duty, correct?
As a law enforcement officer, yes, sir.
Okay. And was there a time that Mr. Reeves would carry an off-duty weapon with him?
Sure it was. We were obligated to uphold the law whether we were off-duty or not.
Did you ever observe Mr. Reeves carrying a .380 Kel-Tec as an off-duty weapon?
No, sir, I did not.
You never saw him practice with that weapon?
No, sir, I did not.
Never saw him fire that weapon?
No, sir, I didn't.
May I have a moment, Judge?
You may.
Mr. DePaulis, you would agree with me, would you not, that the firing of a firearm is the last resort in a particular situation?
Deadly force is the last resort, yes, sir.
Right. And again, Mr. Reeves was trained to de-escalate situations, correct?
He would have been trained in that aspect, yes, sir.
Okay. Nothing further, Judge.
Thank you, Mr. Garcia.
Just briefly.
Promises.
Mr. DePaulis, the prosecution asked you whether you had ever deployed your firearm and fired your firearm against an unarmed person. Remember that question?
Yes, sir, I do.
I believe your answer was that no, you had not done that.
That's correct. It's the reason I hesitated was the one time in my career when I did use deadly force, the person had a weapon, but he hadn't loaded it, and I didn't know that at the time I used a deadly force.
Now, if you were confronted with a situation where an unarmed man was in the process of coming to attack you, and you had fear of death, serious bodily injury, or that a forcible felony was going to be committed against you, would you have any problems whatsoever using deadly force in that scenario?
I would take into consideration a number of factors. I would not rule out the use of deadly force against an unarmed person if I felt that my life would be threatened. And again, your mind races with a number of factors. And one of the factors is if you know you're armed and the other person overpowers you, he may use that weapon against you. So that's another factor that has to be considered.
Okay. And so what you're telling the prosecution today is that, yes, I would use a firearm, deadly force, to protect myself against an unarmed man under certain circumstances that I view at that point in time, correct?
Objection is the leading, Judge.
Overruled.
Correct?
That's correct. There are circumstances where I would use a firearm as deadly force when the person was not armed.
And decisions as to whether or not to use deadly force sometimes have to be made in a fraction of a second, correct?
They have to be made very quickly, yes, sir.
No further questions.
All right. Thank you, Mr. Escobar. And thank you, sir. You will excuse as witness.
Thank you.
All right, it is 12:25 by the courtroom clock. Is there anything further we can do before we take our 1-hour lunch break? Defense, is there anything we can do before we take our 1-hour lunch break? All right, we'll be at lunch until 1:25 then.
All right.
Mr. Escobar, do you need him for a few minutes, or do you want to talk to him back? All right, talk to him back. Mr. Michaels, Mr. Garcia, did you want to look at that video during lunch? Mr. Escobar indicated that he wanted to. You want me to look at that during lunch? The video to make sure we're on the same page, or I think you've done that?